Good morning from me too. I would like to thank Professor Tsoutsos for this invitation. It's an honor and a pleasure for me to be here. We are going to make a presentation in two parts. The first part will last for 30 to 35 minutes, and then we shall have some minutes for questions. However, it would be preferable if you have any questions during the presentation, please do not hesitate to interrupt me and ask your question. This is the best thing for me. I would also like to apologize because only this morning I realized that Professor Tsoutsos had sent me a template of the presentation. So there wasn't any time left for me to transfer all my presentation to the new templates. Therefore, I only took the first and the last page. Sorry about this, Professor Tsoutsos. Okay, I hope this doesn't cause a problem to you. So I think we may begin. Sorry, I had to take off the screen all these things. I don't know how to do it. Okay. I don't know how to do it. Okay, I managed the first one. Well, these are the contents. We are going to see 8 points. I think these are the most crucial points for someone who wants to make a patent. Either he is a researcher or he works in a TTO office. I will put the time. So, first we shall see the intellectual property rights at a glance, just an idea what is the intellectual property rights, the IPRs. Then some examples of the inventions linking material sustainability and cultural heritage, just examples. Then we shall see the 3 prerequisites that have to be present, all the 3 of them, in order to get a patent. And then we shall go to the protection of the invention and the procedure to protect it, how you get a patent. So, intellectual property rights, the IPRs, are legal rights, says the law, attributed to creations of the human mind, which means that you have to be a human to get IPRs on something you have created. You cannot have IPRs on something created by nature. So there are creations of the human mind, such as, for example, inventions, industrial designs, trade secrets, literary, artistic works, such as books, written texts, software, music composition, aesthetic creations, paintings, lyrics. So a patent is a kind of intellectual property right. It protects an invention, and an invention always solves a technical problem. So you cannot have a patent for a music, for a composition, or for a painting. You have a patent for a technical creation of a human mind, which technical creation has to solve a technical problem. So this is a diagram, let's say, a drawing. So all of these are intellectual rights. It's not just one intellectual right, okay? So there are patented inventions, there are trade secrets for non-patented inventions, there are registered trademarks, copyrighted work, and designs, industrial designs. So actually, most of the times, a researcher who has a research output, a result, doesn't have only one of these, doesn't have only an invention which might be patented. Most of the times, the researcher will do a publication. We write a scientific paper. So he will also have copyright work, not only an invention. Maybe later on, he will set up a company. Then that company, which might be a spin-off, will exploit the results, so that company will have registered trademarks for the product, etc., etc. So keep in mind that you don't have only one of these IPRs. Most of the times you have a combination. So let's go to the patents. what is a European patent? You will see at the bottom of the slide, I put the articles. Okay, for further reading, for anybody who wants to do some further reading or research. So the European patent is a legal title granted to the owner of the invention. It confers to the owner the right to prevent or stop others from producing or commercially exploiting the invention within a specific geographical territory. So the patent confers the right to the owner to prevent others from reproducing or exploiting the patent. However, this has as a result that the owner of the patent is the only one legalized to reproduce the patent and to exploit it commercially. Okay? Because a patent actually is a monopoly of rights for a person to do such specific acts within a specific geographical territory for a specific period of time. So it's a bundle of monopolies. Here are the institutions competent for grant procedure and patent granting. First of all is the WIPO, the World Intellectual Property Organization. Here you see the logos, okay? So the World Intellectual Property Organization is the first one. The second is the European Patent Office of the European Patent Organization. Here is the logo. And then we have the national patent offices, as the USPTO, the United States Patent and Trademark Office, the Austrian, the Belgian, the German, the Greek, the Polish, the Romanian, the Spanish Patent Office, etc. Here you see all the logos. So, just a few words about these institutions. The PCT cooperation treaty and the institutions and the legal framework, okay? The PCT is the Patent Cooperation Treaty. It was signed in the 1970s, ratified by 158 countries until today. It is administered by WIPO. By filing one international application, the procedure is simplified. Inventors can choose between 158 states to protect their invention just by filing one international application. The head offices are in Geneva, and the PCT, because you're going to hear this word PCT, I'm going to file for a PCT patent. There is no PCT patent. The PCT is a part of the procedure. It provides extra time to the applicant. To do what with the extra time? Maybe to raise funds or to find to some companies to make a cooperation. So the PCT procedure is what we say an international patent or a worldwide patent. However, the PCT procedure does not lead to patent granting. It's just a part of the procedure. Afterwards is the patent granted, the patent granting within the national offices, not in WIPO Geneva PCT. The second legal framework, the second act, is the European Patent Convention. Signed in 1973, it established a uniform legal system for granting patents across member states within the EPO, the European Patent Office. It has been ratified by 39 states until today, all EU countries as well as non-EU countries such as Norway, Switzerland, Turkey, etc. By filing one single application leads to a bundle of patents in those states chosen by the applicant, as we shall see later on. Yes, the EPC leads to the grant of the European patent. This patent will be valid when it is validated in the states chosen by the patent owner. Head offices are in Munich, The Hague, Berlin, and in the end is the library. The third one is a very new one, the unitary patent. It is based on two EU regulations of 2012 and also of the Unitary Patent Agreement, which was signed in 2013, and set up a unified patent court. So the unitary patent means that after patent granting, the patent owner may request his patent to have unitary effect on the territory of the 18 member states who have ratified that unitary patent, that EUPSA agreement. So one unitary patent is valid and covers 18 states with one annual renewal payment. This, yes, leads to the grant of a unitary patent. It is in force since June 2023, which means that when the applicant finishes this procedure in front of the European Patent Office, then he gets a European patent and he may ask for validation on the 18 states without application. So he gets a unitary patent for these 18 states. Of course, he may, as we see later, he may proceed, take national patents to the other states. And the last important legal act is a TRIPS agreement, which was signed in 1994 within the World Trade Organization. It established minimum protection standards for IPRs among its 166 members. It facilitates the trade and innovation, of course, and it covers different IP subjects, patents, copyrights, trademarks, industrial designs, trade secrets. It establishes the national treatment clause, which means that the foreigners of a country which has ratified the agreement will have no different treatment than the national, and it does not lead to the patent granting. Okay, so we have a patent granting in Europe through the EPC, European Patent Convention, only. So at the end of each part, because the presentation has 8 parts, at the end of each part, I have a very compilation of, a short compilation of reference to famous inventions, just to take a short break of some seconds, and to ask any question if you want to ask any questions until now. So, inventions linking
I do,
materials.
if I may.
Yes?
The question I wanted to ask you is if there is a difference in the cost of a unitary patent compared to the previous process. So what would be, the cost of somebody to patent in several, let's say, jurisdictions, like several countries, compared to the cost for the unitary patent?
Yes, I think, Yanis, we shall see this later on this presentation. Yes. Thank you. So, inventions linking material sustainability and cultural heritage. We shall see some indicative examples. These inventions might be products or might be methods. For instance, a method or device for identifying and determining what type of material, marble, stone, etc., a monument is made of. This invention, method and device, might be a product invention or a method to produce the product. For instance, a software. Other examples, system of devices and elements, e.g., sensors, transmitters, receivers that measure data on monuments regarding the condition of the monument, its age, any cracks, humidity, maximum permitted traffic limit, etc., etc. This system of devices, of the sensors and of the screens, etc., is a product invention and or a method invention running the system, for example, with the software. Other examples, recycled cement technologies for adaptive reuse of historic structures. These cement technologies might be product and or method as well. Low carbon and ultra high performance concrete materials, often reinforced with fibers, silicon fume, etc. This is also a product and or a method to produce that product. So you may ask a patent for both product and method to produce the product. Biodegradable and compostable material alternatives, plant-based like mushrooms, or natural materials designed to break down into non-toxic components. Again, here, the applicant might ask for an invention for a patent on a product and or a method to produce that product. And recycled and bio-based materials for heritage restoration, also products and method of production that material patent. because in order to produce a material, you have the final product, the material, and also you have the method to produce that material. So it is best to ask for both. Material for repairing, replacing missing parts of monuments, and or method for applying that material. Green building materials for low impact restoration. An eco-friendly and or durable and non-toxic product for preserving, cleaning, and restoring historical structures and artifacts, or method for producing such products. Electrospan fabrics for conservation, advanced nanostructured hybrid adhesives, and eco-friendly coatings, prioritizing minimal environmental impact, low environmental impact on the object and its surroundings. So, this refers to famous invention. You see the plane, of course. Okay, it's astonishing if we see that this happened in 100 years only. And you see the Wright brothers in the middle, and some of the spacecrafts of today. So, the third part is patentable inventions, patentability, 3 prerequisites. Now, this part is short, is strictly legal. However, it's not difficult. These are, maybe some might say that these are knowledge for expertise. Maybe this is true, but they are very, very easy to acquire knowledge. It's not something difficult. So, in order to get a patent, 3 prerequisites must be fulfilled. All of them. The novelty, the inventiveness, and the industrial applicability. First of all, we have to say that patenting means that the applicant must make a full disclosure of the invention. So, the documents he has to file to be granted a patent are these 4 documents. 1, 2, 3, always. The 4th is optional. So, the first one is the description of the patent. The description of the patent is a clear and complete disclosure for it to be carried out by the person skilled in the art. So, it is not just a description. It must be written in such a way that the person skilled in the art, the expertise of that specific field of the invention, must be in a position to carry it out. So the description must be detailed. Otherwise, the applicant will get a research report from the examiner saying that your description is vague and unclear and you cannot get a patent. So we have to be very, very, very specific and clear. The second is the claims. The claims define the matter for which the protection is sought. They shall be clear and concise and be supported by the description. So we have, after the description, we have to mention exactly for which points of the patent we ask the patent, which is the monopoly that we said before. We have to be very precise and concrete. The third is the abstracts. The abstract is very short and it's not so important. And the drawings, they accompany the description if there are drawings. There are not always drawings. So the patent, so we apply for the patent and we file to the EPO or to WIPO or to the national office these 4 documents. And then the examiner will examine those documents and he has to examine whether those documents, especially the description, reveal something that is new, presents an inventive step, and finds an industrial application. So, the law says here that an invention shall be considered to be new if it does not form part of the state of the art. The state of the art is held to comprise everything made available to the public by means of a written or oral description, by use or in any other way before the date of filing of the European patent. So everything that was revealed to the public before the filing of the application is not new anymore, any longer. So the red flag here is disclosure, publication of the invention before filing for a patent destroys patentability. Professor Ogrinis mentioned that problem earlier when he said that the universities press the the researchers to reveal, to make publications, to make scientific papers, etc. So this is a real problem because all these acts such as advertising, scientific publications, selling of the product, social media, exhibitions, etc., all these acts, if made before the filing of the application, destroy the novelty of the patent. You cannot get a patent if you have made any reveal any kind of publication of the disclosure of the patent before you file for the patent. So this is number one. Maybe if you are about to keep one thing from this presentation today, please keep this one. Do not make any reveal of the invention before you file for the patent. The second prerequisite that has to be fulfilled is the inventiveness. An invention shall be considered as involving an inventive step if, having regard to the state of the art, having regard to what is new, what is known, if having regard to what is known up to date, the invention is not obvious to a person skilled in the art. So the person skilled is the examiner. Okay, the examiner is not a lawyer. The examiner is a scientist of the field of the invention. So he's an expertise. So the examiner will compare the invention with the state of the art, the known things, the known information. He has to say that what you have done is not obvious in comparison to the state of the art. If it is obvious, this prerequisite is not fulfilled. If it is not obvious, this, which is a very difficult prerequisite, is fulfilled. So, for instance, if I have this mouse pad and with a light, and I put a second light, I have novelty probably because there isn't any other mouse pad, mouse with a second light on it. So the examiner will tell me, okay, you have novelty. There is no other mouse with a second light, but it's not inventive. What you've done is obvious. It's not a big thing. It's obvious if I compare a mouse with two lamps with the previous mouse of the state of the art with one lamp. So I will not get a patent for this. It's something very easy. Everybody could do it. And the third one is an easy prerequisite to be fulfilled, industrial application. An invention shall be considered as susceptible of industrial application if it can be made or used in any kind of industry, including agriculture. And actually, all the inventions are susceptible of any kind of, some kind of application in any field of agriculture or technology or whatever. Reference to famous inventions. Here we have the bulb. And of course, Thomas Edison, who had more than 100 patents, 1,000 patents, and Nikola Tesla, who made some of the most important inventions in human history. Actually, he wasn't very much interested in the patents, Tesla. He was interested in the inventions. So, the last part of this first part of the presentation is the protection of the invention, whether it shall be protected with a patent or as a secret formula. So there is a dilemma here, a dilemma which must be faced by the TTOs as well as by the institutions, by the companies, by the researchers, by anybody. Should I patent my invention or should I keep it as a trade secret? And it is said here that what is worth copying is worth protecting. Yes. However, we must always try to find the best way to protect something, its patent. So one form of protection is the patent, another is to keep it as a secret. It is an ad hoc decision. Yes, it is a decision that it must be taken regarding the specific product or the specific method. So the question to be answered is the product or the method copyable? What does it mean, copyable? It means that is it possible for my competitor, if he examines my product or my method, to find out how I did it? If the competitor will find, by examining the product or the method, can find how I did it, I have to get a patent. I have to protect it by a patent. I have no other way to protect the product or the invention or the method. Because if he may find how I did it, he will reproduce it. So I have to go first and file for a patent and protect it before I circulate the product or before I apply the method. However, if the answer is no, if it is not copyable, which means that if the competitor cannot find out how I produce the product, how I manufacture it, or how I produced, which method, which are the steps of the method which I apply in order to make that product, if he can't figure out, he can't make reverse engineering, as we say in the software, to find out how I apply that method, then maybe the best way to protect the invention and method or product, whatever, maybe the best way is not to get a patent. Maybe the best way is to keep it as a secret in the company, in the university, in wherever, as long as it is possible to keep it as a secret. So here we see famous trade secrets. The channel number 5, it is first put in circulation in 1921. These products have known ingredients, but unknown process of production. The KFC is a secret fried chicken recipe, secret since 1930. We know the ingredients, we don't know the process of production. The Google algorithm is also secret. He could get a patent in the US as a software program, but it didn't. The stealth technology also could have produced. These are known ingredients and known process. And of course, the most known trade secret in the world, the Coca-Cola formula, secret since 1886. The ingredients are known, are on the get-up, on the bottle, on the can, but it's unknown the method of preparation. A patent will grant only 20 years of protection to all these creations, because the patent is the reveal, the specific detailed reveal of all the invention, and we saw as we mentioned earlier. So by not getting a patent, but they managed to keep it secret in the company. This is another chapter, which needs another presentation. However, a patent will grant them only 20 years of protection. So it's time to make a short break of 5, 6, 7 minutes if you don't have any questions.